Hello and welcome to this, my second TCC video law report. Thank you very much for those of you who provided some constructive criticism in response to my first. I will do my best to take that into account. As to my peers in chambers who had some very disparaging things to say about my efforts, I am undeterred and I'm going to carry on regardless. So, case number 2, CC construction against Mr. Raphael Mincione. So this was a contract for the construction of a shell and core of what can only be described as a superhouse in SW1. It incorporated a JCT contract and boiled down to the series of steps that were necessary to get to the issue of a final statement and the conditions that had to be met before the final statement would become binding and conclusive. So here completion had been achieved, although it was achieved late, and a certificate of making good defects was issued by the employer, even though no notice had actually been given of any defects that had to be remedied. The contractor then issued a final statement. There was then a series of steps, which I'll come on to later, before the employer issued a letter disputing that final statement. And the employer then issued another certificate of, or rather a notice of making good defects, even though, yet again, no defects had actually been notified. All of this led to an issue about whether or not the final certificate or the final statement had actually achieved final and conclusive effect, and that was referred by the contractor to an adjudicator. Now, the adjudicator determined that the final statement was binding and conclusive under the express terms of the agreement, and also said that he didn't have jurisdiction to consider the cross-claim, the liquidated damages claim raised by the employer. Now, the parties were pretty much geared up for a fight by this stage, and we know that because they both issued proceedings independently on the same day. The employer issued proceedings for various declarations, the contractor issued proceedings for enforcement of the adjudicator's award. And this came before His Honour Judge EWHC, and he had 3 issues to determine. The first was what the due date was, and that had to be resolved by whether or not there was a valid certificate of making good defects, or whether time should run from the date of the final statement. Then the next issue was whether the employer had validly challenged the final statement, so that the final statement did not have binding and conclusive effect. And finally, there was the general issue as to whether the adjudicator's award was enforceable in any event. So the first issue as to the certificates of making good defects, rather than notice of making good defects here, we go down to paragraph 86 for the decision on this. Now, it's not necessary to read this out, and we get a little bit too bogged down in the particular clauses of this particular contract and the bespoke amendments associated with it. But essentially what's interesting here is the judge rejected any suggestion that it should be interpreted one way or the other because the employer was a private individual or anything like that. The judge stepped back from it, said, well, I'm going to just look at the words used in the procedure set out in the contract. I'm going to apply common sense, the normal interpretation of the words that have been incorporated into the parties' bargain, and I'm going to apply those words. And that's what he did. And in this case, I'm not saying that this is going to be the case for all contracts under the JCT, or because every decision will turn on the particular terms that are used, but in this case, the judge concluded that in order to issue a notice of completion of making good, what I've been referring to as a certificate of making good defects, an initial notice to require the contractor to remedy the defects is necessary. And in effect, by issuing that notice, it was meaningless and couldn't have the effect that the employer wanted it to have, which would be to push back the due date. So I think that if you read the rationale of the judge here, it's very straightforward, and it just applies a common sense interpretation to the clauses that were incorporated in this particular contract. The next issue was whether or not the employer had effectively disputed the the final statement that had been issued by the contractor. And here we have to get a little bit more into the chronology of the final statement. The first statement was issued and the employer apparently didn't receive it or wasn't aware of it, and that led to the contractor reissuing it a little more than a month later, appending what had been previously issued. After receipt of that second final statement, if you want to call it that, the employer wrote his letter challenging it and explaining the basis why. Now the question, what the employer did, however, was refer back to the first statement, which he said he hadn't received, and didn't expressly refer to the second one that resent it. And the question was whether that notice was an effective challenge of that second notice. Now I think that most of us, I would hope that most of us would think that through, think the chronology, and just think, well, don't be so ridiculous. Of course, this was a challenge of the second, even though the first one was being referred to. But thankfully, the law doesn't break it down into simply a matter of the application of some vague notion of common sense. We do apply a test. And at paragraph 91, both parties agreed what the test should be, that the interpretation of the letter sent by the employer should be how it would have been understood in the particular circumstances by a reasonable recipient aware of the surrounding facts. And having accepted that that's the test, it's not surprising that in that context the judge found at paragraph 94 that a reasonable recipient of the employer's letter would be in no doubt the employer was disputing the final statement which had been resent after having originally been sent on the 5th of October. Accordingly, the letter operated as an effective notice of dispute for the purposes of clause 4.12.6. Now, following on from that, there was then another dispute as to whether or not the employer had to not only give this notice challenging what was in the final statement, but whether he also should have issued proceedings. And similar to the first issue, paragraph 97, the judge goes through this in careful detail, looking at the clause, not stretching the interpretation by any means, giving the ordinary and natural meaning to the words incorporated in the contract. And he found that actually what the contract said was that there were two ways to make a challenge to the final statement to prevent it from becoming binding and conclusive. The first was to issue a letter like the employer did, and the second was to issue proceedings, that you didn't have to issue both. But again, this is all down to the particular terms of an individual contract, interpreted with the common sense of a judge sitting as a high court judge. So that was the answer there. So on the declarations sought by the employer, we get to the point that the final statement was potentially binding and conclusive because the certificate of making good defects was ineffective, but ultimately that a successful challenge had been raised so that the final certificate did not have a binding and conclusive effect. Now, you would think it's not necessary at that stage to then move on to the enforcement of the adjudicator's award, but for the sake of completeness, we've got the decision on the enforcement here as well. And there were two issues here that are of note. The first was whether there was actually a dispute at the time of the notice as to the binding and conclusive effect of the final statement, and second, whether the failure of the adjudicator to consider the liquidated damages claim was a breach of natural justice that rendered the decision unenforceable. Well, it's worth at this stage, we do like a little bit of a summary of the law every now and then, to refresh our memory of AMEC and Secretary of State for Transport, in which Mr. Justice Jackson set out his test as to what is necessary to crystallise a dispute for the purposes of adjudication. First, the word dispute occurs in many arbitration clauses. It doesn't have any special or unusual meaning conferred upon it by lawyers. The fact that one party notifies the other party of a claim doesn't automatically give rise to a dispute. It's clear both as a matter of language from judicial decisions that a dispute does not arise unless and until it emerges that the claim is not admitted. There may be an express rejection of the claim. There may be discussions between the parties from which objectively it's to be inferred that the claim is not admitted. The respondent may prevaricate, thus giving rise to the inference that he does not admit the claim. The respondent may simply remain silent for a period of time, giving rise to the same inference. The period of time a respondent may remain silent before a dispute is to be inferred depends heavily on the facts of the case and the contractual structure. And finally, an interesting one, which actually I'd forgotten, I hadn't read this case for a while. If the claim as presented by the claimant is so nebulous and ill-defined that the respondent cannot sensibly respond to it, neither silence by the respondent nor even an express non-admission is likely to give rise to a dispute for the purposes of arbitration or adjudication. So in here, the fact that the employer was trying to say that the issue of conclusivity was never expressly raised in the correspondence between the parties, and that on that basis there can't have been a dispute as to it. But the judge stood back and had a look at the correspondence between the parties as a whole, and found that actually in the manner in which and the language used by the employer in challenging the final statement, it was very clear that had the potential to incorporate the dispute over conclusivity, and therefore the judge held that there was a dispute at the time of the notice that was capable of being adjudicated. Well, what about the issue of failing to consider the counterclaim for liquidated damages? Well, this actually raises issues very similar to Downs Road, the first case that I reviewed. And he goes through a very similar test. You'll see that this is actually no more than 10 days, a judgment handed down no more than 10 days after Downs Road, and it follows similar logic, albeit there's a twist here, because the adjudicator in this case could have said the binding and conclusive effect of the final statement, which he held that was the effect of the final statement, that could have been binding and conclusive as to time as well. Now, if the adjudicator had gone on that, followed that train of logic, he could have reached a decision on the merits of the underlying claim and dismissed it. But he didn't do that. What he did is he said that because he didn't consider that it was covered by the scope of the notice, that ultimately he didn't have jurisdiction to determine it. So the law, again, if you haven't listened to the first report, here it is again, but it's Pilon and Breyer. The adjudicator must attempt to answer the question referred to him. The question may consist of a number of separate sub-issues. If the adjudicator has endeavoured generally to address those issues in order to answer the question, then, whether right or wrong, his decision is enforceable. If the adjudicator fails to address the question referred to him because he has taken an erroneously restrictive view of his jurisdiction, then that may make his decision unenforceable. And obviously, it goes without saying that any such failure must also be material. Now, here I think this didn't actually come through in Downs Road, but here's a bit of extra text from Mr. Justice Coulson, as he then was. It's not uncommon for adjudicators to decide the scope of their jurisdiction solely by reference to the words used in the notice of adjudication, without having regard to the necessary implication of those words. That was, for example, what went wrong in Broadwell. Adjudicators should be aware that the notice of adjudication will ordinarily be confined to the claim being advanced. It will rarely refer to the points that might be raised by way of defence to that claim. As a result, an adjudicator should think very carefully before ruling out a defence merely because there was no mention of it in the claiming party's notice of adjudication. So, we get to a knock on the door there. I'm going to try and endeavour to go through, because I've tried this talk a number of times and I don't want to be distracted from it. At paragraph 118, the judge summarises the conclusion here. It follows that summarises his position on the law here, I should say. It follows that where there's a claim for payment, a defence of set-off can be raised and will necessarily be part of the dispute, which an adjudicator addressing such a claim has to determine. It's important to keep in mind the distinction between A, considering an asserted defence and then concluding as a result of that consideration that it's not a tenable defence in the particular circumstances, and B, declining to consider whether consider an asserted defence. The former will be an exercise which the adjudicator will have jurisdiction to undertake, and a conclusion that the defence is not tenable, even if expressed in short terms, is unlikely to involve a breach of the rules of natural justice. Conversely, the latter is likely to be such a breach. So, as I've already foreshadowed, here at paragraph 131, he concludes that because the adjudicator was absolutely clear by reference to what was in the notice of adjudication that he didn't have jurisdiction to determine the claim for liquidated damages, that was a breach of natural justice, whereas had he gone along and decided that the effect of the final statement was binding and conclusive on those matters, then that would have been enforceable. So, what are the lessons we can draw out of this this judgment? Well, the first is interpretation of the contract, procedural issues. You simply have to apply the normal, everyday interpretation of the words that are there. If the procedure says that you have to do this before you can achieve that, then you have to go through those steps, and there's absolutely no mandatory requirement that you have to issue certificates and notices if ultimately there's nothing to be covered by those issues and notices. So very often we're tempted to go down the line of taking a very detailed view of these things, and that can lead to an absurd outcome in terms of your analysis, and it is always very important to step back, think, what is the overarching purpose of these provisions, and apply common sense to them. And second, I suppose, to adjudicators, this is the second judgment in 10 days where an adjudicator has excluded an issue from his decision, rendering that decision unenforceable. So be very, very careful if you're going to be excluding a defence raised by the other side or by the defending or responding party. You must consider all the issues that are put before you that are relevant to the issue that you're determining. Hope you found that useful. Again, I will try and improve and get quicker with my next one. Next one looks like it's an interesting one. 4 members of chambers involved in the judgment I'm doing next. So I hope you enjoy that one.